This is from a famous series of photographs taken in the early 1970s in Boston. A photographer was basically on his way home and he heard some screams, shouts or whatever, and he sort of ran to where the noise was coming from and he just started to take these photographs. And you can see this woman, child, fireman on a fire escape and the ladder moving ever closer. And now you see it collapses. And it tells you at the top here actually what happened. So the young woman actually died as a result of this fall. And the child fell on top of her and survived. But this is perhaps the most shocking or disturbing photograph. What makes this disturbing? It's perhaps only when I tell you it's real. It's not a film set. And I think that's what makes us gasp a bit and you know, nobody's smiling right now. It's a very moving sequence of images here. So this is my question to you. Imagine that you are owner-editor of the Boston Herald newspaper back in the 1970s. The background context here is that the newspaper is struggling financially. And an hour before print deadline, a photographer comes running into your office and shows you the negatives of these 3 photographs that I've just shown you. Are you going to print them? What are you going to do? The first thing to say is you have to make a decision. There is no sitting on the fence here. It's an either or, right? You either print or you don't. Although I suppose you could decide to print the first image and not the last. But let's just talk this through as best we can in this video context. When I pitch this to the class, I get nearly always a handful of people who would print all of them, all of the photographs. The justification for doing so is one that we've already looked at when we were talking about television. It's the justification that you are the editor-in-chief, CEO, if you like, of an organization, a company, and you have a fiduciary duty to maximize the profits of that business, of that company, for the shareholders. And of course, we know from the context I've given you that you desperately need some kind of stimulation here to sell, because otherwise you could be closed in a matter of weeks. These photographs, you know, will incite interest and help you sell newspapers. So, I mean, that's the justification for doing it. You might then sort of feed in some kind of public interest justification that this is a terrible event and people should know about terrible events. We shouldn't, you know, be blind to them. And maybe this actually touches on a health and safety issue, that people should know about the security risks raised by these fire escapes and so on. So, I mean, those would be, I suppose, the arguments for printing all of the photographs. And after all, we don't actually see the impact photograph. Maybe there are other arguments I'm missing. But if we turn to the counter-argument, what my students tend to say is that this is voyeuristic, it's exploitative, we're seeking to make profit out of a personal tragedy. We are using images without the consent of the, you know, figures who are in this these images, And with the hour print deadline, there's no time, and so it wouldn't be in the 1970s, there's no time to contact relatives or family to warn them of these images, to seek permissions or anything. It seems for many people in my classes morally reprehensible to publish these. So we usually have quite an argument about that, and then I show them this image, which was taken during the Vietnam War, about the same time period, probably early 70s, late 60s maybe. So, I mean, many of you will have seen this photograph. It's very famous. The village in the background, I think, has been napalmed, and these poor children have been caught up in the conflagration. And the poor child in the center of this image, well, you can see what the fire has done to her body. She actually survived and has made a life for herself in North America. There's a kind of, sort of happy ending, if you can put it that way. But it's very, very disturbing. So the question I put to you, just as I would in class, is, do you print this photograph? Imagine the same now. Imagine the same sort of context. Would you print that photograph? And perhaps the more interesting question is, would you be changing your mind, or better to put it, would you be distinguishing between these images so that, for example, you would have been against printing the Boston fire escape photographs, but you would print this one? How would you distinguish the images? The argument is often made that the Vietnam War photograph can be distinguished from the other photographs because it goes more profoundly to the public interest. The public should know about the terrible things that are happening in this war. And perhaps they don't. So they need to be informed. The counter-argument, and of course many students just don't change their minds at all, they would not print the Boston ones and they would not print this, is because they find it similarly intrusive and exploitative. In this case, we actually have a naked girl in the center of the shot here. There's no consent granted. She's going to have to live with this image for the rest of her life. She hasn't given permission for this. She's a child. So, it's a very strong counter-argument, isn't it? But the argument for printing it is strong too, isn't it? If people don't know about what's going on. You see how difficult this is? I hope you do. And in a sense, I guess what we're asking is where do we draw the line here? What is in the public interest? Because I think that's what this comes down to, doesn't it? If we're talking about publishing an image to the world, then we ought to be considering our reasons for so doing. And if it is because we think the public should know about it, then how do you define public interest? I'm reminded of Princess Diana. I guess you know about her, right? From the 1990s and earlier. I mean, she died tragically, obviously, very much as a focus of the paparazzi. But there was an occasion when a photographer working for the News of the World, I think it was the News of the World, it's one of these tabloid so-called newspapers we have in the UK, a photographer managed to hide a camera in a gymnasium that she frequented. The clear purpose of this was to take images of her in revealing poses as she was working out. She was tipped off, and before publication, an application by her lawyers was made to the High Court for an emergency injunction prohibiting the publication of these photographs. This is an application you can make to the High Court at any time of day or night. You can apply to the court or to the judge at 4 o'clock in the morning if necessary and actually get them out of bed. Although I suppose you better have a damn good case if you're going to do that. Anyway, the judge summoned to his chambers the, I guess the editor or owner, whatever, of the News of the World, or the newspaper concerned at least, and said, here are these photographs. How do you justify the publication of these photographs? And the answer was, well, Your Honor, it's in the public interest. Very good. Can you please define for me what you mean by the public interest? Yes, Your Honor, it's what the public's interested in seeing. Is that good enough? I wonder. Some people would say yes. But many people would say no. And indeed, when one looks at the media today, the online news media that's out there, it's difficult not to think that they're operating with that self-same definition. What we tend to have is celebrity gossip, salacious news. It seems to be appealing to our prurient interests. It's designed to titillate us. I'm on no pedestal here. It's almost as though we consume it. But is this healthy? Where should the line be drawn? And we're moving ever closer to Cambodia, that book that we're going to be studying in a few weeks' time, because in many ways that book is about this very question. Who gets to decide what we see? Because if you're out there watching this video and you've been saying, no, I wouldn't publish that, and no, I wouldn't publish that, and people shouldn't see that, you are a censor. And who the hell do you think you are on your moral pedestal telling me what I can watch and what I can see? You know what? I'm on the pedestal too, to be honest with you. But it's uncomfortable. We talked about this a bit earlier in a previous video. It's uncomfortable to feel that we are censoring, but that's exactly what we're doing. So yeah, tricky. The next thing I do in the class is put up a blank piece of paper on the screen and in my melodramatic way explain that there's something underneath it. And then I tell the students that what's underneath it is a Danish cartoon. And that usually concentrates the minds of a few of my students who immediately know where I'm going. But in case you don't, the cartoons I'm referring to were published in a Danish newspaper back in 2005. And it was a similar context in the sense that the newspaper was struggling financially. And so published, I think it was 12 cartoons, which were bound to be incendiary to the Muslim community in Denmark. I mean, for two reasons. I mean, firstly, I think the Quran prohibits any pictorial representation of the Prophet. And secondly, the actual content of the cartoons. I mean, in one of them, for example, the Prophet is wearing a stick of dynamite in his turban. It's pretty obvious, crude humor. But my question is the same. So imagine that you are the owner editor of that Danish publication, struggling financially. Do you print those cartoons? This is where it gets really interesting in the classroom. Because the number of students who enthusiastically say yes dwindles considerably from the Boston photographs, but there's usually one or two who say, yeah, definitely, we should print. I would print. And the majority of my students in the classroom are against it. Let's, as critical thinkers, force ourselves perhaps to consider the counter arguments here, beginning with the argument for printing them. What is it? What is the argument for printing these cartoons? Well, we could argue the same fiduciary duty to maximize profits. This is obviously going to boost sales. This newspaper will sell like hotcakes because of the controversy. So we could make that sort of justification for doing it. But there's actually another justification for doing it, even an ethical one. And it takes us to one of the core principles, ethical principles, arguably, of a liberal civil society. And of course, where I'm heading is freedom of speech. I remember, going back a fair way now, I used to be an altar boy, a Catholic altar boy. Can you believe that? I'm a very bad Catholic now. But anyway, there I was, and I remember a film came out, Monty Python's The Life of Brian. Some of you will know it and will be smiling. Some of you don't know it. Perhaps you should. It's brilliant, arguably very funny and brilliant. And it's a complete lampoon of the whole story of Jesus, right? Anyway, this film came out, I think it must have been sometime in the 1980s, and the priest said in the church, this is blasphemous, and there's a petition at the back of the church, and I want you all to sign it on the way out, and then as a diocese, we're going to send all our petitions down to 10 Downing Street and make sure that this film is censored and cut. So I dutifully trooped out of the church and signed the petition, and then the following Saturday evening I went to see the film, and on Sunday I went to confession. It's the wonderful thing about Catholicism, you can actually plan your sins in advance. Anyway, you get my point, hopefully. The point is that in our liberal civil society, our democracies that we live in, people are free pretty much to say anything, aren't they? I mean, if we make fun of the whole Christian thing and the Jesus thing, I'm thinking of Family Guy as well, why the hell shouldn't we be allowed to make fun of Islam? Well, that's the argument for doing it. The argument against is what we know will happen. So it is within the reasonable foresight of anybody printing these cartoons that they will be incendiary. They will cause offence and serious social disruption and possibly despair as a result. Since we know that that will be the result, should we still print the cartoons? And we arrive, I hope you understand this is a difficult issue, although you may be clearly on one side or the other. As you probably know, they were printed under the banner of freedom of speech, no doubt, and they caused the predictable unrest and disruption. They were reprinted throughout Western Europe, I think in La Libération in Paris, and there were riots, and also in London there were riots, casualties as a result. And you know where we're headed, don't you? Because we're headed to Charlie Hebdo in 2015. This was a traditional kind of French satirical publication. They reprinted the cartoons. I think they reconfigured some of them. They received death threats. I think in 2013 there was a firebombing in their offices. And then in 2015, two gunmen went into the Charlie Hebdo office in Paris and shot dead 12 of the cartoonists and workers in the office. I mean, so you can see the tragedy that unfolds from this. It's actually interesting because very, very recently, just a couple of weeks or so ago, they, I think it's not celebrating, but marking the anniversary of this shooting, they reprinted the cartoons again. Um, difficult. And the difficulty leads me to my second question, which is whether I should show you now the cartoons. So, I mean, in the classroom, it's a little bit more melodramatic because they're there actually on the screen, but they're under a piece of paper so you can't see them. And I say to the class, should I now reveal the cartoons to you in this classroom? And I always get one or two, enthusiastically saying, yeah, come on, show it. Sometimes it's a lot of students saying yes and nodding. And I always have a few kind of, like that. When I was preparing this class a few years back, my wife said to me, there is no way you show those cartoons because it would take just one student to complain and you're going to lose your job. And I said, no, freedom of speech, freedom of speech. If there's one place on this planet I should be free to show you anything, it's surely for pedagogical purposes, instructional purposes, in a classroom at Capilano University in Vancouver in the 21st century. Anyway, determined I was, driving to work the next morning, I found myself asking, is there a Muslim in my class? And then I realized I didn't have the balls to do it. And I never have found the balls to do it. What I do is simply tell the students that if they want to see the cartoons, they can come up to me at the end of the class and see them. And of course, if you want to see them, you just bloody Google them, right? It's not difficult for you to do, but I think it needs to come from you. It needs to be you coming to me or you Googling rather than me just projecting the images to you. I do remember a student running out of the class in tears when I even mentioned the cartoons. And it turned out that she was Muslim, she had relatives in London, and who had been involved in this difficulty. So you can see what a touchy, difficult, and dangerous subject this is. And it's in a sense all about censorship and where we draw the lines when it comes to freedom of speech. And let's not forget, freedom of speech is pretty bloody important. The common denominator of dictatorships is that there is no free press. So it is freedom of speech which provides for a free press, which holds our politicians to account. So that's the importance of it. But of course, as we've been looking at, it can go too far, perhaps. So there we are. In thinking about censorship, what I want to do, and because I want to drill down a bit more on legal language here, I want to take you to a famous case in the US to do with censorship, and you can see it's a Supreme Court case, again from the mid-70s, and it's the case of Uznosnik and City of Jacksonville. Before I let you read that, let me just give you the context because it will help. Uznosnik owned and ran a drive-in cinema or movie theatre, which are becoming increasingly popular now. You get it, right? So you sit in the car and you look at this huge screen in the field. And there we are. So I do not know what film was showing on this particular night concerned. And I do not know what the act of nudity was in that film that night. But somebody driving on the highway past this field saw an act of nudity on the screen, they were offended by it, and the next morning went to the City of Jacksonville's mayor's office and complained. And as a result, the mayor's office closed the film down. Now, Uznosnik didn't like that and went to court and won his case, so the film was back on. City of Jacksonville didn't like the decision of the district court and appealed, and they won their appeal. So now the film is off again. Uznosnik obviously had a lot of money behind him and backers, managed to get this up to the Supreme Court, where he eventually won his case, so that the film was, if you like, effectively back on again. So let's just have a look at this. Oops, I've got the wrong one here for you. At this case, you can see the title, you can see it's an appeal from the District Court of Appeal, the lower court. 75, and then you can see this heading here, Jacksonville, Florida Ordinance or Order, Judgment, making it a public nuisance and a punishable offense for a drive-in movie theater to exhibit films containing nudity when the screen is visible from a public street or place, held facially invalid as an infringement of First Amendment rights. And then at the bottom, you can find that of the multiple judges, 3 of them disagreed with this result. So Rehnquist, Berger, and White disagreed with the finding of the court here. So I put this on eLearn as a document, but well, I'm going to let you read this for a couple of minutes. I'm going to zip out and come back, and then we'll have a chat, okay? Okay, feels a bit better. Now, I'm assuming that you've read the whole thing. First thing I want to, the main reason for doing this is to practice some critical thinking, but first thing is to ask you about the language. How would you describe the language of this text? So what do you do? What do you do when your instructor asks you to describe something? You don't just look for what's there, you look also for what isn't there, right? So what's there is a kind of flat, neutral tone, the use of sort of base imperative verbs, some jargon, and what isn't there is any figurative language, right? You know, there are no metaphors, similes, or anything like that. And that combination, if you like, makes it what we would call monologic text. I've done this with you already, okay? So it's authoritarian text. As far as possible, it is text which seeks to resist interpretation and argument. So there are little clues to that. Whenever you come across saying must or should or something, you know, it's suggestive of monologic text. We also have these adverbial qualifiers. Look at this first paragraph. Held facially invalid. Grammatically, there's no need whatsoever for the word facially. All a lawyer is saying when they say facially invalid is it's really, 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 really invalid. Yeah? There's another one down in paragraph C, strikingly under-inclusive. It's just, there's no need for the word strikingly. It's just there to try and batten down the meaning, to try and sort of make it a closed text. Now, insofar as what we have in front of us is an example of monologic text, we can distinguish it from the dialogic text of legal argument. So we have sort of subgenres. Yes, legal argument, but there are subgenres. There's legal judgment and there's legal argument. I don't want to stress the distinction too much. You can find legal judgments that are 200 or 300 pages long. Lord Denning used to quote poetry in his judgments, all right? So, but at least in a redacted version, such as we have here, I think the distinction holds. With legal argument, it is often the case that you will use figurative language. I mean, you might stand up in court and say, ladies and gentlemen of the jury, my client is desperately sorry that he crashed his vehicle into Safeway, killing 3 people and 2 dogs. But my client is a pillar of the community. And that morning he lost his goldfish, his wife left him, he lost his job. But my client is salt of the earth. You get the thing, you get the idea. You can feed in these images to try and build up your argument in defense of the client. And in so doing, you are appealing to the jury and the judge at a level of pathos. Now, that won't be enough. Almost certainly you're going to have to feed in the facts of the case and the factual matrix, and this is where your speech will turn towards logos, and you will start to factor in logical arguments in defense of your client. All right? Thinking about argument like that, figurative imagery used in argument, it actually reminds me of a dinner party that I had just before the whole Corona thing. And it was fabulous because a friend of mine got drunk. And I love it when he gets drunk because he gets really aggressive and difficult. And he had a go at this woman around the table who's the wife of a friend of mine who's a dental hygienist. And he was saying dental hygienist is absolute crap nonsense. I mean, just floss your teeth. And, he was saying it's just an invention of American dentistry just to make extra profits. We don't need dental hygiene. And, naturally she was very offended, but she's very smart. So she defended herself by saying, no, you don't get it. She said, it's like when you're golfing, you have to clean the grooves on your irons. Otherwise you won't get spin on the ball when you hit a shot. And that really set him off. He was like, golf, teeth, analogical fallacy. You can tell he's an English prof, right? You should come to my dinner parties, they're great. And I sat there thinking, this is brilliant because she's being really smart. This is about Kairos and Prepon. I mean, she knows her audience. We're all golfers sitting around the table. We're all very bad golfers. But we all get the principle of spinning the ball, and it's going to be difficult to do if your club's covered in crap, right? So smart. She knew what she was talking about, and she appealed to us in the right way. And don't get me wrong. I mean, if you stand up in court and start talking about, golf balls and things like that, well, you need to do it judiciously, otherwise you won't get away with it. All right, now, let's look at the arguments here. And of course, we're remembering that there were 3 judges who just didn't agree with this finding. So paragraph A, the ordinance, by discriminating among movies solely on the basis of content, has the effect of deterring drive-in theatres from showing movies containing any nudity, however innocent or even educational. There's a problem with that, isn't there? Just read that again. As a critical reader, what's the problem with that argument in paragraph A? You see, how else do you discriminate among movies unless it be on the basis of content? It's like I bake a cake and I fill it with jam and cream and lovely gooey lovely things, and then I bake another cake and fill it with shit. How else do you distinguish the 2 cakes unless it be in terms of their contents? All right, and I just used a simile, by the way, to make my case. Has the effect of deterring theatres from showing movies containing any nudity, however innocent or even educational? But there's another problem, isn't there? What they seem to be saying, the judges here, is that if the scene of nudity is innocent, or if it's educational, then that makes it okay. But hang on, what if I'm just driving on the road, on the highway? I'm not even attending the movie. I've got Jimmy and Sue in the back of the car, and suddenly Jimmy's pointing at that movie screen over there saying, "Papa, what's that?" And I'm like, "Ask Mama." You know, does it matter whether it's educational or not? There are lots of problems here. There's another one. Look at this. And such censorship of the content of otherwise protected speech cannot be justified on the basis of the limited privacy interest of persons on the public streets who, if offended by viewing the movies, can readily avert their eyes. What is the problem with that? What the judges seem to be saying here is if you see it and you don't like it, you can readily look away. What's the problem? You've already bloody seen it. You're already offended. Odd, right? One more. Why don't we go to paragraph B? Nor can the ordinance be justified as an exercise of the city's police power for the protection of children against viewing the films. Because even if that was its purpose, the restriction is broader than permissible, since it is not directed against sexually explicit nudity or otherwise limited. All right, what is sexually explicit nudity? I mean, are you drawing pictures in your minds now? I mean, what is sexually explicit here? If you had been a porn director in England back in the early 1980s, you would have been tearing your hair out with frustration. This is not why I lost my hair, by the way. You would have been tearing your hair out with frustration because they kept changing the definition of sexually explicit nudity. All right? And they did it by statutory instruments. You didn't have to completely rewrite the act. You can just kind of feed in different definitions. So, I mean, to begin with, you are not allowed to show an erect penis. Okay, at least that's clear, right? Then they kind of shifted it a bit so that you could show an erect penis provided it wasn't engaged in sexual activity, which kind of blows the mind a bit. It's like, whatever. And then, believe it or not, they shifted it again so that you could show penetration and an erect penis provided the audio track did not suggest sexual activity. Now, just think about that for the moment. I mean, you now have a sub-genre of pornography with sexually explicit material and the soundtrack of, I don't know, Disney's Bambi over the top. Ridiculous. And then, of course, it was all shifted back to the starting point with the arrival, I think it was John Major's Conservative government and family values and back to basics. So, okay, I'm having a bit of fun with you here, but there is actually a serious point to this. And I've mentioned it before in the last video. Definitions are the weak points in texts. So when you are set with critically analyzing a text, never forget that. Never forget contrast, never forget all the other things I talked to you about, but never forget the definitions, because that's what you can shoot at. If you have a definition which you think is insufficient, too broad, so that it's actually a hasty generalization, it's fallacious, then you have a way of actually starting to critique what's in front of you. And of course, you should be very aware of this when you're writing your essays at university, to make sure that your definitions are as precise as they can be and you don't run foul of the same problem. Okay, now, the broader reason why I'm taking you to the law is because that is where rhetoric comes from. If you go back 2,500 years to the ancient Greek world, Athenians were suing the crap out of each other. If anything, it was way more litigious as a society than it is today in Vancouver or New York or London or wherever. And there were reasons for this. I mean, the first was, I guess the first was that you could make money they had the same pecuniary notion of damages, that you could win if you won your court case. You could get your costs, um, and you could get damages as money. So you could make a lot of money actually getting involved in court cases. So that was one reason. Another reason was, I think, to do with, well, what else are you going to do? So, okay, you are an Athenian citizen in, say, 450 BC. So you get out of bed and you sort of stretch and oil yourself and eat a bit, and then you go to the gymnasium, you sort of work out and, wash and oil yourself and eat a bit, and go back to the gym and work out and, wash and oil yourself and eat. The slaves are doing all the work, right? So, I mean, what else are you going to do? There's no television, there's no internet, there's nothing to, So why not trip down to the forum and check out today's court case? Because it's intrinsically dramatic, isn't it? Particularly if it's a criminal case. And best of all, if you're an Athenian citizen, you get to belong to the jury. I mean, the jury could be 5 people, it could be 15 people, it could be 5,000 people. You get to vote, right? You get to have a say. So it was very popular. It was almost primetime entertainment. And there were some people who realized that they kept winning their court cases, whether they were claimant or defendant. They just kept winning. And rather like sort of modern day management consultants, they sort of set themselves up as consultants to help you win your court case. They called themselves sometimes logographers, sort of speech makers. They called themselves sometimes sophists. But basically, they were the first teachers of rhetoric, and they set up schools of rhetoric to teach people how to win court cases. One such famous teacher was called Corax. He opened a school of rhetoric. One day he was approached by a would-be student called Tisias. Tisias didn't have any money. So they entered into an arrangement, why didn't we call it a contract, for the provision of a service. So the idea was that Corax would teach rhetoric to Tisias for, I think it was 2 years or so. And 2 years after graduating, Tisias would repay the tuition, probably with an extra element added. So there we are, there's the contract, and you can just now imagine what happened. So Tisias studied, he graduated from the School of Rhetoric. 2 years passed subsequently, and he did not pay the tuition fees. He was too lazy, he was in the bar, the brothel, whatever, he just wasn't getting involved in court cases. And so Corax sued him for non-payment of monies owed for a service rendered. And we have the famous case, actually documented, of Corax and Tisias. Everybody tripped down to the forum that day. Tisias stood up in front of the jury and said, listen everyone, if I successfully defend the case made against me, then obviously I don't have to pay the tuition because I've succeeded to defend myself, right? But if I fail to successfully defend myself today, that can only be because my rhetoric wasn't good enough to persuade you, the jury. And if my rhetoric hasn't been good enough, he taught me. So why should I have to pay him for something that actually doesn't work? It's like I commission someone to build me a boat, and then I take it to sea for the first time and it's got a bloody hole in it. So what am I supposed to do? Am I supposed to throw money to the boat builder as I'm about to drown? Corax stood up, apparently very agitated, and said, this is ridiculous, right? I mean, if I succeed in my claim today that he's got to pay me the tuition money, that's it. But if I fail today, it can only be because he's persuaded you, the jury, using the rhetoric that I taught him. So even if I lose, I should win. Well, the jury deliberated, and the judges apparently got very upset and annoyed about the whole thing. And they ended up giving a verdict. In Greek, it's kakou korakos kakon un, which is kind of a play on words, because I think Corax, the translation is from a bad crow, a bad egg. and Corax is the root meaning of crow, and TCS is the root for egg. So you can see how they're playing on words here. But the bottom line here is that the ancient Athenian court is saying, go away. This is frivolous and vexatious litigation. Each party pay their own costs. But I think it was actually more than that. If you think about it, this case itself was very incendiary and dangerous. You know, there is, I'm sure in Canada, a Sales of Goods and Services Act. I know we have one back in England. And it establishes a statutory protection for the consumer, whereby the goods or services sold must be of sufficient quality or fit for purpose. So there's kind of a statutory warranty there. What Corax was selling was a service, and he was selling the law. He was basically saying, come to me, after 2 years, you'll win. It doesn't matter whether you have a justifiable claim or not. And it doesn't matter whether you're guilty or not if you're the defendant. You know, stick with me for 2 years and I will give you the language, the argument, the argumentative skills to win. Either way. That's dangerous, isn't it? And so you can see why the court reacted the way that it did. And it also helps to explain, I think, why the word sophist has kind of changed in meaning as you go through time. Back then, it was just simply describing someone who did this, who taught rhetoric and who was also skilled at argument in other fields, in all sorts of fields, you know, science, mathematics, philosophy, so on. But today, if you're called a sophist, chances are the person means that you are deliberately deceiving and using language in a mendacious way. You're being slippery and sneaky with language. I think sophist now is almost a pejorative term, and perhaps the reason for that has its roots in that very court case that I was telling you about. What these two guys would have done, actually, standing up in court in their speeches, is follow a program that I'm going to show you right now. Here we are. A mode, a method, a sequence of arguments. And this actually is, if you like, an extension of what we were looking at in the last video on the 5 canons of rhetoric. I think the second canon is arrangement. So we invent, we come up with ideas, and then we have to think about how we're going to arrange our arguments. Well, in law school today, they may well teach you this sequence, which comes from the ancient world. Whether it's an opening speech or a closing speech, you would have the introduction, where the attorney, the lawyer, announces the subject and purpose of the speech, perhaps with an element of ethos. You then have the narratio, the statement of facts, so giving a summary of the charges and the law. The division, so the legal issues that might be in dispute. Then the proof, presenting logical arguments. And then perhaps introducing some pathos too, as we discuss. And then refutatio. Remember, I mentioned this to you in the very first video. And you can see now the kind of elements of refutatio: metastasis, contrarium, precedent. You're already familiar with precedent, aren't you? But metastasis, denying and turning back on the opponent an argument used against you. Contrarium, proving an assertion by discrediting its opposite. And then the peroration, the conclusion. You don't need to learn this for English 100, don't worry about it if you're not interested, but some of you will be, and I just thought you'd like to know, and this gives you some kind of a sequence which I hope will be of assistance to you. Let's never forget refutatio, okay? The more you think, as I said to you before, the more you think and plan how you are going to meet with the counter-arguments, the better you will be at argument. And let's not also forget something I've repeated in this video so far, the importance of figurative language in making an argument. If you want to make an argument for X, and you can make a bridge to Y, where Y is already accepted by your interlocutor or the people you're talking to, then your argument for X is going to be stronger. That was the point around the dinner table, arguing about golf. She was clever, she knew what she was doing. Right, now, finally, and this won't take us very long, just a little bit of revision on grammar. And I think it might be the last I do in English 100 with you, so it's just kind of honing our skills here. So what would be absolutely the best is if you were to now spend some time going through this, deciding for yourself where you think the corrections need to be made. And I've deliberately given this to you as a text and e-learn. So, get it on the screen and perhaps start putting in commas, apostrophes, whatever, where you think they need to be, semicolons, whatever, or print it out and do that. That's going to be absolutely the best exercise here. Those of you who are absolutely fluent in this will just wait for me to carry on the video, all right? Or you probably already stopped the video. But do that and then come back to this video, and then I will take you to the corrected version, okay? That's what I suggest you do. All right, so I'm going to trust that you've done that, if you haven't already run away from the video. And here we have the corrected version. Different ways of skinning the cat, as they say. And so some of these are negotiable, they don't need to be there, and some of these punctuation marks absolutely have to be there, okay? So at the beginning we have, I think, an introductory element. You don't have to have a comma after living. It's okay, but I think stylistically it's clearer if you have a comma there. And really that's what punctuation is about, isn't it? It's about clarity. Two things developed anonymously, in opposition. That is a sentence. We now have a list of two or more things, and so therefore we need to have a colon. Remember, if we have a sentence followed by a quote, we use a colon. If we have a sentence followed by a list of two or more things, we use a colon, which is what we have here. Do you have a comma between music and noise pollution? No, because it's two things. It's not three. If it was three, then we would have a list and we would start putting commas in for the lists. But here it's just two things, and they're both equally important, and that's why there would be no comma. But there is a comma after pollution. Again, because for the sake of clarity, we now finish the clause, we finish the sentence with a period outside period. After art music had moved indoors, comma. Again, always think about clarity, because it's often, if you are stuck and you are proofreading your research essay in whatever class, you should read it to yourself aloud. You really should, or to someone. It helps so much, because if you say after art music had moved indoor street music, I'm confused. Are you talking about indoor street music? No. What you mean is after art music had moved indoors, after that, then this. And so it makes sense. You need a comma here, all right? Street music became an object of particular scorn, period. Hogarth's celebrated print. I'm willing to bet that apostrophe is not there in some of your texts, because it's not there in many of your essays, right? You need the apostrophe. The print belonged to Hogarth's. It's possessive. You have an apostrophe before the S. The Enraged Musician. So that is the title of a print. What do you do with it? I didn't know, so I just used the CAP guide, rifled through MLA, and it tells me that you should italicize or underline a print. So, okay, I've underlined it here. Shows the conflict in full view. A professional musician indoors clamps it. I've put that in commas because I think it's like an extra thought in the sentence. Grammatically, it doesn't have to be there, but we're putting it in as if it's in brackets, as if it's in parenthesis. Could be brackets. Commas are better, stylistically, in the humanities. But if you haven't put anything there, I think you would be all right, just about. It's better with. Clamps his hands over his ears in agony. Again, I think you should have a comma here for clarity. And this is almost a non-restrictive element at the end of a sentence, so that's another reason why I would have a comma here. But I think you could just about get away without anything after agony. And then some students put outside his workroom in brackets, or they put outside his workroom in commas. That would be okay. That would be okay. It's just a question of style there, I think. But the colon is absolutely necessary. I hope you get that, right? Because you have a long sentence now followed by a list of things. I just told you what to do. You need to use a comma, colon, these two dots, right? So now we have the list. The baby is screaming, comma, a man is sharpening knives on a grindstone, comma, children are playing with ratchets and drums, comma, several hawkers are selling wares assisted by wells and horns. This is the Oxford comma now, as we call it. It's either there or it isn't. I don't give a damn. And one shabbily dressed beggar has targeted the musician's window. The window belongs to the musician. Possessive, you need an apostrophe. It goes before the S. If it was more than one musician, it would go after the S. And then we have the end of the sentence. The developing antagonism between music and the soundscape can be more clearly sensed by comparing Hogarth's print with Bruegel's Town Square of a century earlier. Hogarth's print contains glass windows. Bruegel's painting does not. Bruegel's people have come to the open windows to listen. Hogarth's musician has come to the window to shut it. See the apostrophes. See the period. And note, as a final remark on this, that all these periods at the end could be semicolons. And in fact, that's what I probably would have done. Otherwise, it's a bit clunky, isn't it? Just, you know, a period is a much stronger semicolon. Maybe that's the way to put it. So semicolons soften the separation between independent clauses or sentences. And so stylistically, perhaps semicolons would be better here at the end. But, you know, periods are absolutely fine too. All right, enough of that. Short and fairly sweet today. In the next video, we will turn to some short stories and maybe a refreshing change from the rhetorical analysis we've been working on so far. Thanks for your time and see you next time. Bye for now.